Good afternoon and welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website. I would ask those in-house if you'll make that last courtesy check that cell phones have been turned off. It is always appreciated. And we will, of course, post the program within 24 hours on the Heritage home site for your future reference. And our internet viewers are always welcome at any time to send questions or comments to speaker@heritage.org. Hosting our discussion this afternoon is Paul Larkin, Senior Legal Research Fellow in our Edwin Meese Center for Legal and Judicial Studies. He directs Heritage's Overcriminalization Project to counter abuse of criminal law, particularly at the federal level. From 1994 to 93 at the Department of Justice, he served as an assistant to the Solicitor General and as an attorney in the Criminal Division section on crime and racketeering. He has also argued 27 cases before the Supreme Court. He then served as counsel to the Senate Judiciary Committee and head of the crime unit for Senator Orrin Hatch, who was chairman of the panel at the time. And from 98 to 2004, he was at the Environmental Protection Agency as a special agent for criminal enforcement. In the private sector, he has worked for two major D.C. law firms and as well as an assistant general counsel for Verizon Communications before joining us here at Heritage. Please join me in welcoming my colleague, Paul Larkin. Paul?
Thank you very much, John. I appreciate it. The revolution in technology and telecommunications over the last few decades has made life easier for us in numerous ways. We use Google Map directions to find wherever we're going. We shop online for everything from tennis shoes to groceries to cars to homes. We carry our cell phones with us wherever we go. And we post our thoughts and opinions on various social media websites. All of that makes life easier for us in a variety of ways. At the same time, those inventions also make it easier for the government to track our whereabouts and record our lives. And, as the Bard would have said, therein lies the rub. We want the government to implement contradictory policies. On the one hand, we want the government to respect our privacy, but on the other hand, we want the government to prevent terrorist acts and capture criminals. The problem is we cannot eat our cake and have it too. This debate over where to draw the line between those policies will be played out in the halls of Congress, in the Academy, in think tanks like this one, and in those same social networking sites that the government, like everyone else, can use to see our opinions. But there is another important player in this process, namely the courts, particularly the Supreme Court of the United States. The Fourth Amendment to the Constitution prohibits the government from engaging in, quote, unreasonable searches and seizures, unquote. And it is the job of the courts to give that phrase meaning. The Supreme Court is the final authority on that phrase, and it has had several occasions recently to address how it should be applied in light of new technologies, such as GPS tracking systems and DNA analysis. Because what the court has said and what it will say is so important to our lives, we have three experts here today to discuss how the Fourth Amendment should be read and how the Supreme Court will read it in light of these new technologies. Let me introduce our panelists. On your far right is Susan Herman, the president of the American Civil Liberties Union. And I have to say, the ability, probably, Susan, to say that you sat on the far right at Heritage is something that you may treasure for the rest of your life.
Thank you.
It's our far left, though.
It's our far left. Stage left.
She has also served on the ACLU National Board of Directors, on its executive committee, and as its general counsel. She is a graduate of Barnard College and NYU Law School. Presently, she is the Centennial Professor of Law at Brooklyn Law School, where she teaches courses in constitutional law and criminal procedure, as well as terrorism and civil liberties. A highly regarded authority in constitutional law and criminal procedure, as well as a prolific author, Professor Herman has published numerous articles in scholarly journals and law reviews, as well as several books. Her most recent book is Taking Liberties, The War on Terror and the Erosion of American Democracy, published by Oxford University Press in 2011. For that book, she received the 2012 Roy C. Palmer Civil Liberties Prize from the Illinois Institute of Technology, Chicago-Kent School of Law. She has appeared on numerous radio and TV shows. Leading print and media journals publish her opinions, and she has spoken at the U.S. Army War College and at many other schools. We also have today Professor Orin Kerr. Professor Kerr is the Fred C. Stevenson Research Professor of Law at the George Washington University School of Law. Professor Kerr holds mechanical engineering degrees from Princeton and Stanford, and he has a law degree from Harvard. Recognized as one of the nation's leading scholars on the relationship between the Fourth Amendment and new technologies, Professor Kerr has published some of the most prominent articles on that subject in the Harvard, Yale, Stanford, and Michigan Law Reviews. Aside from being a prolific scholar, Professor Kerr has briefed and argued cases in the federal district courts, federal circuit courts, and Supreme Court of the United States. Before he began teaching in 2001, Professor Kerr was a lawyer at the Computer Crime and Intellectual Property section of the U.S. Department of Justice, where he worked after clerking for Justice Anthony Kennedy. From 2012 to 2014, Professor Kerr is also serving as the scholar in residence at the Law Library of Congress. Our third expert is Miguel Estrada. Miguel is a partner in the Washington, D.C. office of the law firm of Gibson, Dunn & Crutcher. There, Miguel is co-chair of the firm's Appellate and Constitutional Law Practice Group, as well as a member of the Business Crimes and Investigation Practice Group. Miguel received his undergraduate degree from Columbia University and his law degree from Harvard Law School, where he was an editor of the Harvard Law Review and a magna cum laude graduate. Miguel was a law clerk for Judge Amalia Kurse on the U.S. Court of Appeals for the Second Circuit and Associate Justice Anthony Kennedy of the U.S. Supreme Court. Following his clerkships, he worked at the U.S. Attorney's Office for the Southern District of New York and the Office of the Solicitor General at the Justice Department. Miguel has argued 20 cases before the Supreme Court of the United States and has filed briefs in a far, far larger number. Journals such as Legal Times and Washingtonian Magazine have listed him as one of the premier lawyers in America. The members of the Supreme Court Bar, that is, the lawyers who follow what the court does and argue cases there, recognize Miguel as a truly superlative lawyer, and I have the additional privilege of being able to call him my friend. Welcome. We are glad to have the three of you here today. We look forward to hearing what you have to say. We will now hear from our experts in the order that I introduced them.
Well, good afternoon, and thank you, Paul, for the lovely introduction and also for the invitation. It's a great pleasure to be here. I guess I was thinking, looking around of who I've known at Heritage over time, and several years ago I debated Paul Rosenzweig, and he was gracious enough at the beginning of our debate, even though we were about to go at it on the Patriot Act, start out by saying that he really valued the ACLU because we serve as the canary in the mine. So I thought I would start out, before digging into the Fourth Amendment, as Paul has invited us to do, and telling you why I'm afraid that the air is getting a little thin in here. And, of course, that's my perspective. I've never been at the Department of Justice. My job is to worry about the unintended consequences and the innocent people and the information that the government is picking up that's not the information that they were really going after. So in order to start, what I would like to do is to start by focusing in on the values underlying the Fourth Amendment before we start getting into its interpretation. Now, as you all know, the Fourth Amendment protects people in their persons, houses, papers, and effects. And as you all know, over time, many justices have looked at those words and believed that the Fourth Amendment is only about tangible things, about places and physical things and physical intrusions. Now, Katz, which overruled the old Olmstead case, which had taken very much that view, I think is absolutely right in saying the Fourth Amendment protects people, not just places. Again, you've seen many different things over the years in how the Supreme Court has interpreted that language. But to me, part of the idea of the Fourth Amendment is that it's not just about protecting private physical spaces. It's about protecting private enclaves in a way that I really relate to the First Amendment. So my idea of what the framers had in mind when they were drafting the Fourth Amendment is I get a picture of Benjamin Franklin's desk. And back in those days, what Benjamin Franklin would have had in his desk was everything. His correspondence, his notes, and his drafts of Poor Richard's Almanac, whatever he had was going to be in his desk. And therefore, whatever he was thinking or writing to people or talking about was protected against any sort of intrusion without a search warrant, because that was in his home. Now, what's happened today, as Paul was just describing, is that technology has moved a lot of the contents of Benjamin Franklin's desk to spaces that, because they're in the control of third parties, are considered to be effectively public spaces. Now, in addition to posing problems about how do you interpret the Fourth Amendment, I think that really starts posing a challenge to the whole idea that people should have a private enclave. And this idea that you can separate the public from the private, I think, becomes increasingly problematic. And I want to talk about, I think I probably only have time in my initial comments for part of this, but I'd like actually to talk about a critique of why the Supreme Court has been so far behind the curve in its interpretation of the Fourth Amendment. And there are three doctrines, all of which are sort of basic to the Fourth Amendment, all of which I think are very problematic. One is the third-party doctrine itself. Another is the distinction between metadata and contents. And a third is the Katz test itself. So starting with the metadata, and what I want to use as an example, because it couldn't be more current, is the NSA surveillance. It's not the most sophisticated technology we have to worry about, but we know that the NSA is using its capacity to do massive call tracking on Americans, and what they're doing is they're collecting all of this metadata. Now, when the Patriot Act first was enacted in the fall of 2001, as you all know quite quickly with no hearings, et cetera, the idea of the Patriot Act was to retrofit previous law, to try to provide the government with more tools to fight terrorism. And so what the Patriot Act did was it built on existing loopholes, spaces within the Fourth Amendment, where the government felt that they would have more leeway to find out whatever they wanted to find out, to just gather information without having to go through as much process or have as high a bar in terms of individualized suspicion. So Section 215, which is centrally involved in the NSA surveillance of metadata, built on the third-party doctrine, and it says that you can get the contents with an order from the FISA court based on a showing of relevance to a terrorism investigation. You can get any records at all from third parties, content, non-content, whatever you want, as long as it's relevant to an investigation. I think that 215 has been overexpanded in the Obama administration's interpretation that NSA can just scoop up all of this metadata without a particular showing of relevance and then kind of hook up the relevance later. But that's one issue. What I'd like to talk about now is first the scope of the collection of this metadata, because here's where I think that the distinction in the old cases between metadata and contents is not as useful as it used to be, or not as telling. So here's the definition under the CFR of what is considered to be metadata and what may be picked up under the metadata. And this is under the Smith versus Maryland idea, that if you're just finding out the pen register idea, you're not looking at the contents of a telephone call, you're only looking at the number, the to and from numbers. So what can be collected are the originating and terminating telephone numbers, the time and duration of the call, and also what's allowed to be collected under this definition is the location of the speakers, although officials tell us that they're not actually collecting information on location. Now, this quantity of information already is pretty big, and I think it just yields a lot more information than would have been available at the time of Smith. First of all, there are new analytical tools in order to analyze all this data. So once the NSA gathers these massive amounts of data, they can use programs like the IBM Analyst and like PenLink to go over all this information and reveal patterns of behavior, relationships, habits, personal details. They can tell if you've called a single-purpose telephone number, a rape counseling hotline, a doctor's office, the ACLU. In addition, what we've heard, and I think we don't, I don't pretend to know everything that's going on because I think the revelations are continuing, and we have to take all this with a grain of salt in terms of believing that we understand how this works. But presumably, the agency is retaining all this information for 5 years, which means they have this enormous digital database. So in addition to having the capacity to search more deeply and find out more about people's lives, they also have this 5-year database of this enormous collection of information. Now, for those of you taking notes, if you write down one thing out of anything I've said, write down the name Edward Felton. The ACLU, right after one of the original Snowden disclosures about Verizon having to turn over all this information about all of its customers, filed a lawsuit called ACLU versus Clapper, because we are a customer of Verizon, And we were quite concerned that all of the information about our telephone calls, who we call and who's calling us, could be available in a government database. There's an affidavit that's filed in connection with this lawsuit, and if you look at the ACLU website as one place to get it, and the documents about ACLU versus Clapper, you'll see this affidavit by Edward Felton, who is a computer scientist who teaches at Princeton, which I found just really eye-opening. In addition to talking about how much can be done, how much information can be derived from metadata, and he gives some pretty amazing examples of what you could piece together just by looking at timing, relative timing, duration, et cetera, of telephone calls. Professor Felton also says that it is much easier to search metadata. Metadata is structured, and therefore it's much easier and more cost-effective. I see hip nodding at people who know how this works. That it's much more cost-effective to search metadata than to search contents, which are not structured. And therefore, the whole idea that what we should be protecting are the contents of telephone calls and that we really shouldn't care about metadata, I think is really just not true. Now, the other thing that we sort of have on hold here is the whole question of location, all the cell phone tracking. And another issue, the sort of concentric circles go on, is the whole issue about internet and email metadata. Now we know, again, what we think we know is that the Obama administration has interpreted 215 to allow it to collect metadata about the to and from email addresses that people have, and also about the websites that people visit. It seems that the FISA court told them that they shouldn't do that, but that's always been something that's been up in the air about is that a proper interpretation and should the government have that power. Now, if you think about it again in terms of the amount of personal detail that is exposed and put into the public sphere because you've given it to a third party, if the internet and email is included, that's an incredible amount of information. What does your internet service provider know about you? Even if it's just metadata, it's all of the websites that you visited. That's extremely telling. And so I think that if Benjamin Franklin today were at home in his desk, and he wouldn't have anything in his desk, he was pretty technologically savvy, all of his information would be on the cloud. So the metadata and contents distinction to me is just not a really good protection in the third-party doctrine. And the third-party doctrine itself is not a really good protection because even though at the time of Smith, it seemed to the court that people essentially consent. They assume the risk when they turn over data to their telephone company, like what number they've called. The world has changed since Smith. That was a very limited amount of information. We now are sharing a great deal more information with our telecoms, with our internet service providers, and I think we have less choice. At the time of Smith, at the time the Supreme Court decided the Miller case, it was more plausible to say, well, if you don't want to yield your privacy, don't make a telephone call. Don't use a bank, keep your money in your mattress. And you can avoid turning things over to third parties. I think it's now virtually impossible. Everybody has, almost everybody in this country has a cell phone. And so the way that we conduct our daily lives is almost entirely, just enormously available to those third parties. And that's why I think the third-party doctrine really needs more limits than the Supreme Court has so far imposed upon it. Will the court be willing to look at the third-party doctrine and think about limiting it? Well, I think they're already thinking about that a little bit. In the Jones case, the case about GPS tracking, you may know that the court split kind of 4-4-1. And the four justices in the majority, Justice Scalia, writing the opinion, took a property-oriented approach to the question of whether a GPS device could be installed on a car. And the idea was, well, that was touching a thing, a piece of property, and it was a property violation. The four justices who only concurred in the judgment, led by Justice Alito, said, no, that's really silly, that's wrong. Nobody interfered with your possessory rights of the property and bad idea. And we really should be looking at this case as a privacy case and applying the Katz reasonable expectation of privacy test. Justice Sotomayor, somewhere in the middle, writes a concurring opinion saying, well, the property ground is okay for now. But we are going to have to get a hold of this Katz idea and whether or not it would violate a reasonable expectation of privacy if the tracking device was pre-installed in your car, in your phone, in whatever. So I think we have 5 justices on the court who know that this is coming, 5 justices who in Jones were very much concerned about the scope of the intrusion, not just the nature. It wasn't enough for 5 of them at least to say, well, anybody can follow your car around and therefore a GPS tracking device is no problem. So I think that's the beginning of the Supreme Court looking at this, but I think it's not going to be easy for them to figure out how to limit the third-party doctrine. The final thing that I think I want to tell you about before my time is up here, well, maybe two more things I'll try. One of the important things, I think, is people say very often, well, why should I care what the government knows about me if I'm not doing something wrong? Well, Paul was mentioning my book. I actually wrote this book to answer that question. It's about the impact of all this on ordinary Americans. And I think I would summarize quickly why we should care as being three reasons. Number one is the chilling effect. I was mentioning before the connections, I think, between the Fourth Amendment and the First Amendment. Now, if people know that in the government database some places, the fact that they have called the ACLU to report misconduct or just, police officer wanting to complain that they've been improperly disciplined, people may be deterred from calling. Now, I know, people have a lot of explanations about, well, it's not that direct and so forth, but I think that every time an American hesitates to call a controversial, place, a political group, or the ACLU, every time an American hesitates to visit a controversial website or to tell their doctor about, they have a drug problem, I think we lose something as a society. So the chilling effect on our rights of speech, association, religion, I think are very important. Number two, and this is the one that I think most people focus on, potential for abuse. The Obama administration has told us that there's really no problem with the collection of all this data because nobody has pointed to any particular way in which the data has been abused or used against political enemies. Now, I think there are several problems with that. Number one, it's happening in secret. If there were an abuse, how would we know? This is all pretty heavy, so let me tell you a story that's really a little bit off point, but I think it's telling. There was a study that somebody did a few years ago of all these video surveillance cameras in the UK where they have, they blanket the country. And the researcher discovered one particular place where the guys who operated the video surveillance cameras, which were tilt, pan, and zoom cameras, about 10 or 15% of the time that they used those cameras, the guys in the office were using them to focus on particular parts of women's anatomy. And then when they saw something they liked, they would make a picture of it and put it up on the wall of the office. Okay, now did those women know that? No. And we don't know what's happening behind the closed doors. So I think you can ask, this is like the tree falling in the forest. Is it a privacy violation if you don't know and don't feel the pain? Well, I'm kind of concerned about that anyway, because in terms of potential for abuse, number one, we can't really know what's happening behind closed doors. Number two, there are a lot of different people hired by the government. And some of them are going to be extremely responsible, and some of them are not going to be so careful about how they use this secret data. We have Edward Snowden himself as a good example that we can think we're keeping data secret, and authorized people may leak it, unauthorized people may find a way to hack into it. So I think there's a tremendous potential for abuse when you have the collection of that much data. The Obama administration's argument has been basically, trust us, we don't intend to misuse this data. Well, where have we heard that before? And there will be other administrations. There are going to be a lot of people who have control of the data. Finally, point number three to why should we care. I have a quote here that I want to read you because it's one of my favorite quotes about the Patriot Act. And this was Elaine Scarry, who teaches English at Harvard, and she sure can write. She says, the Patriot Act inverts the constitutional requirement that people's lives be private and the work of government officials be public. It instead crafts a set of conditions in which our inner lives become transparent and the workings of the government become opaque. Either one of these outcomes would imperil democracy. Together, they not only injure the country, but also cut off the avenues of repair. Elegant, right? Isn't that nicely said? But I think that that's the third problem here. What the Fourth Amendment and First Amendment are about is our ability to participate in democracies. And I think the subtitle of my book, The Erosion of Democracy, is that this really is a threat to our democracy because it changes the relationship of the individual and the government. There have been rather direct challenges to citizen participation, like the gag orders under Section 215 and national security letters. But I think it's really a very important difference. So when people say, well, if Amazon knows everything about me, who cares if the government does also? Well, last time I looked, Amazon couldn't even threaten to put you in jail. So I think having the government having all this data is quite different from having the data in private hands. Okay, so the final thing I'm going to say with my introductory remarks here is that Justice Alito in Jones says, okay, the solution here, we don't really, this is going to be hard for the courts. What we really need is we need for legislatures to get on top of this. And legislatures are going to do a better job than courts are of figuring out whether there should be limits. And indeed, there are several bills pending in Congress to rein in this collection of data. The Amash Conyers bill in the House and the Udall-Leahy bill in the Senate both try to tighten up the grounds on which the records can be obtained. They're using the relevance standard more, and they're trying to narrow the collection. Because I think the back-end controls are not going to be enough. The massive collection in itself is a problem. But I think part of the problem with leaving this to Congress is it may be Congress will do something about this, and it may be that they'll do some wise things. But I think that ever since, well, with the third-party doctrine is some of this, and ever since Katz, the Supreme Court, I think, has really abdicated its role in interpreting the Fourth Amendment. The whole idea that the Fourth Amendment is about reasonable expectations of privacy and what society is prepared to protect sounds to me majoritarian. It sounds like if most people think it's okay to collect information, that's okay, and therefore our legislators are the best representatives and spokespersons for what the majority of people want. It seems to me that the Fourth Amendment, like the First Amendment, like the Second Amendment, should be interpreted to be counter-majoritarian, and that it is really the court's job to articulate what the values are in the Fourth Amendment and what the limitations should be on government officials doing this kind of surveillance. That would mean really the court owning some values in the Fourth Amendment, and I think the court has just not been willing to do that for various reasons. They've been deferring to the legislature, deferring to society. So where I'm going back to, and I see some of this in Justice Sotomayor's opinion in Jones, I'm going back to Justice Marshall and Brennan's dissent in the Smith case. The Fourth Amendment should not be about what we can reasonably expect to be private. That's a pretty, that standard can move. It can be perhaps manipulated by the government, and it's majoritarian. I think the standard should be what we are entitled to expect to remain private, as opposed to what the reasonable person would expect to be private. Okay, so I think that's about my opening time here, so I'm going to yield the floor to Orin.
All right. Thank you very much to the Heritage Foundation and to Paul and to John for the invitation to come here to talk about a timeless topic. And I think if we were having this debate, or if this debate were being held in the 1920s, we would be trying to figure out what do we do about the automobile in crime. And the new technology of the day, of the automobile changed everything when it came to many kinds of criminal activity. And in the 1940s, the big debate is what do you do about the telephone? The telephone changes everything. Now people can talk to each other in private across great distances, and the government wants to listen in. What do we do about that? And in the 1980s, the government started using technologies to try to detect criminal activity that they hadn't used before, such as aerial surveillance, flying airplanes and helicopters, installing radio beepers on cars to try to monitor individuals as they were engaged in potential criminal activity. And the Supreme Court grappled with all of these technologies and has continued to grapple with these technologies to try to figure out how the Fourth Amendment should apply to these kinds of new technologies. And I think because the Fourth Amendment ultimately is attuned to what people are doing in terms of what technologies people are using and what technologies people involved in criminal activity are using, there's a necessary ongoing development of Fourth Amendment law, which is constantly responsive to new technologies that are being used and employed, that the government is trying to use, and that are just being used by the public. So what we're seeing today is kind of the 2013 version of this question, focused on today's controversies, but I think it's important to realize that every generation, every era has its own version of these technological questions. I think the technology of our day and of the next 10 to 20 years that's going to occupy the Supreme Court is specifically computers and computer networks. If you're familiar with Fourth Amendment doctrine, you know that a surprisingly large chunk of Supreme Court cases in the Fourth Amendment area over the last 50 or 60 years involve the automobile. There's maybe like 30% or so of the Supreme Court's cases are automobile specific. Why is that? As well, there are a lot of crimes that are detected during traffic stops. There are a lot of Drug cases, for example, contraband cases and the Fourth Amendment are always intrinsically linked. And so you have a lot of cases involving the Fourth Amendment in cars in which the Supreme Court announces sort of car-specific rules governing when cars can be stopped, when they can be searched, when they can be seized, and the like. And I think you're going to see the same over the next 10 to 20 years with computers. And I think computers are going to be to the 21st century Fourth Amendment what automobiles were to the 20th century Fourth Amendment. This is going to be a recurring fact pattern that becomes so important given the technologies that people are using that the Supreme Court is going to have to grapple with how to apply the timeless principles of the Fourth Amendment to these new technologies. So that's the broad challenge, and of course the question is how is the Supreme Court going to do that, and how should they do that? And I think if you look historically at how the Supreme Court has done that, what they seem to try to do is to try to take into account new technologies and to try to balance government powers and privacy rights in light of the new technologies that individuals are using. And a good example of this is the switch from the Olmstead regime in the 1920s to the Katz case in the 1960s. And so in the 1920s, it was very rare to use telephones. In fact, telephones were really only for businesses. The idea of personal communications by telephone was kind of novel. And in the Olmstead case in 1928, the Supreme Court concludes that the Fourth Amendment just does not apply to wiretapping a telephone line. And at that time, telephone usage was not that common, and the Supreme Court, in saying that the Fourth Amendment didn't apply, really wasn't impacting tremendously the overall amount of privacy rights that people had. Fast forward to 1967 in the Katz case, and the Supreme Court acknowledges in the Katz case that people are just using telephones constantly. I mean, the majority opinion by Justice Stewart in the Katz case doesn't offer a whole lot of strong reasoning. It's sort of a result and then reasoning to follow, which is why Justice Harlan needs to follow up with his effort to articulate a test in his concurring opinion. But he says, we need to recognize that the Fourth Amendment applies to putting a microphone on a phone booth, because to decide otherwise would be to ignore the role of the public telephone in American society. Well, I would ask you, when was the last time you used a public telephone? When was the last time you saw a public telephone? We no longer use that technology. We now use cell phones, right? So technology just 40 years later has evolved to deal with a new set of problems and new technologies. And the court in Katz was trying to effectively, I think, maintain some kind of balance of government power. If you stuck with the Olmstead regime in an era when people were constantly using phone calls, that would mean that the government had a new way of breaking into private spaces that had become quite important, and you would have an overall lessening of constitutional protection over time. So I think if you look, and I've written long academic articles on this question, but I think if you look at how the Supreme Court deals with new technologies, the justices are pretty well attuned to the problem of either expanding government power as technology changes or restricting government power as technology changes. And they kind of tailor the rules, and there are various doctrinal mechanisms they can use to do that. But they tailor the rules to try to maintain some sort of effective balance of power. So in terms of how they do that, I think it's important not to get too caught up in the sort of formal doctrine, what I sort of call it the principles layer of doctrine, the reasonable expectation of privacy test. So the problem with the reasonable expectation of privacy test is it's kind of like the due process clause. It's a term of art that you can't really interpret literally, or at least if you interpret it literally, you say, gosh, none of these cases make sense. And it's good fun for criminal procedure professors to show the students the Supreme Court's cases and then ask them, would you expect privacy in that situation? The students say yes. And then you say, are you a reasonable person? And they say yes. And they say, so a reasonable person would expect privacy here, right? Yes. Well, why did the Supreme Court say there's no reasonable expectation of privacy? The students try to figure out, I don't know, like, did they just get it wrong, or do I not understand the test? And I think you can't understand the reasonable expectation of privacy test just by reciting the words, much like you can't understand the due process clause just by sort of saying, is something process and is it due? There's just a lot more stuff that's going on. And so I think it's important to look at the results that the justices tend to reach more than the formal doctrine that they tend to announce. And if you look at the formal doctrine, you see the justices trying to respond to technology. And I think the recent Jones case involving GPS monitoring is a really good example of this. I mean, on its face, Justice Scalia, in his majority opinion in Jones, is returning to the trespass test for what is a search, sort of a part of a longstanding originalist methodology that Justice Scalia has been trying to further. And on its face, the concurring opinions are sort of applying the reasonable expectation of privacy test. But what's going on there, I think, is really an effort to respond to the increased government power that goes along with the ability to install a GPS device. If the government can now watch everyone's location easily and cheaply and comprehensively over a long period of time, that is a quite significant expansion of the government's ability to monitor people. And so you see the justices, 9-0, a surprising vote count, respond by coming up with various ways to counteract that expanded level of government power. So I think that's the overall tradition here. And there's some kind of Burkean sense, I think, to that idea of tailoring constitutional protections to respond to technology. And there are various, from a different theoretical perspectives, I think you can justify that result as well. So I find it interesting, Justice Scalia, the originalist, will do this under an originalist guise. Justice Brennan, under a living constitutionalist, would do the same under a living constitutionalist approach. Justice Breyer is a pragmatist. Same kinds of results. They can all justify these results using various parts of Fourth Amendment history and text. And so all kind of collectively, I think, end up responding in a similar way to the problem of new technologies. So let me talk specifically about how that might change constitutional doctrine going forward with respect to computers and computer networks. And I do think you have to separate out computers in the standalone environment, that is, not linked to a network, and computers that are linked to a network, because I think they present some different problems. So in the context of computers in the standalone environment, what really changes is that computers can store a tremendous amount of personal information in a very small space. And a great example of this is the cell phone that is probably in your pocket. Your cell phone, probably, it's a smartphone. It's not really just a storage device. It's a very sophisticated computer. It has the storage capacity equivalent to a typical home computer in around 2004, 2005. So you're carrying around a massive library of all your most personal stuff with you. And that causes real puzzles for Fourth Amendment doctrine, because the Fourth Amendment is traditionally about searching physical spaces. So it's one thing, it's easy to say at the outset that when the government looks inside your physical storage device, that's a search, much like looking inside your car or your pockets or your house. That part's easy. But what's the scope of the search that the government is allowed to conduct at that point? Then you run into hard problems, because the Fourth Amendment traditionally has said, okay, the government is allowed to search a private space, but when they have a warrant, they need to particularly describe what they're looking for and what they're searching. Well, given that computers can store a tremendous amount of information on a very small place, and that information can be stored anywhere on the physical device, suddenly you run into the problem that every a search potentially becomes a general search. The government can look through all that data and find tremendous amounts of information about people, and it would all seem to be allowable under traditional Fourth Amendment rules. And I think in response to that, we've begun to see the courts sort of rebelling against the traditional constitutional doctrines and saying there's something about computers which is different. The storage capacity, the fact that information can be anywhere, has a different implication, and they generally justify it on the grounds that reasonableness has a different meaning when the government search is so invasive, and that the physical world rules should no longer apply. An example of this that's currently has 2 cert petitions pending at the Supreme Court, and I suspect we'll see the Supreme Court decide this term, is the question of what are the rules for searching a cell phone incident to arrest. So going back to 1973 in United States versus Robinson, the Supreme Court says that there is a right to search a person incident to their lawful arrest, going back to a common law standard, so not a new standard. But in Robinson, the Supreme Court says that is a bright line rule, no case-specific inquiries. As soon as the person is arrested, there's a complete search of the person and any property on the person. Well, courts have rebelled against this rule, I think properly in the lower courts, as applied to a cell phone search incident to arrest. The problem being that if an officer arrests somebody who's carrying a cell phone, that search of a cell phone can be an extraordinarily invasive thing. It can be not only a search for phone numbers or text messages in the phone, it can be a search for a history of emails, it could be pictures, it could be tremendously private information. And so the line you hear from the old Apple commercials is there's an app for that. And that means there's information related to how that app was used for that, and it's stored on the phone. So suddenly the question is, well, can the government search a cell phone incident to arrest, and is that different from searching a physical item incident to arrest? And I think the court is going to grapple with that question this coming term. Finally, I wanted to turn to the network question, which raises the issues under the third-party doctrine. I tend to think that the third-party doctrine is correct and important, but there's a question of how far it should apply. So let me offer a few brief words on how I think the Supreme Court should apply the Fourth Amendment across computer networks. I think the key idea is to try to maintain some sort of technological neutrality in how you adjust from a physical environment to a network environment. And this was an issue that really arose initially in the postal network setting, when instead of going to meet somebody in person, they would send a postal letter, and the courts had to figure out, can the government look at the outside of the letter, can they open the letter? And then it arises in the telephone network setting with phone calls, and now it's arising in the internet setting with emails and text messages and the like. And I think the sensible way to approach interpreting the Fourth Amendment in response to this problem is to say that what networks do is effectively outsource a task. So in a pre-network world, if you wanted to meet with someone and discuss something with them, you would leave your house, say go to their house, and have a private conversation in their home. What kind of information was available to be observed by the government in that case? Well, they could watch you leave your home, right, because they can watch from a city public street. They could know when you left, they could know where you came from, and they could see where you were going, but they couldn't actually know what the conversation was inside the home, right? That's a Fourth Amendment protected space that the government couldn't enter without a warrant. And I think the metadata content distinction is an effort to recapture that overall balance of power. So the metadata is effectively the kind of information that the government could observe in the physical space when someone was physically going out into the world and going from one place to another. It's where were they, when did the communication occur, where did they start, where did it end, if they're carrying a package, how big is the package? But the government doesn't get to know the contents of the call or communication. That's equivalent to what occurs inside the home, the actual conversation. So the government gets access to some information and not other information. And I think there's a rough equivalence between the kind of information that's available under the content, non-content distinction in the Fourth Amendment to what would be available in terms of physical surveillance of outside versus inside information that we know and are familiar with from Fourth Amendment cases involving physical space. So I think that distinction is a sensible one, although a couple caveats I think are important. One is that it creates a very significant role for the legislature. First, the legislature should be regulating access to metadata, which can be quite invasive information, especially because computerization allows the government to collect, store all of the information, and then allow somebody to look through that database later on and keep that indefinitely. So the switch from the physical to the digital, I think, really introduces a need for legislative regulation that was less pressing, less important in just the physical environment. And then also, I think we need to be aware of kind of the long game here in when we think of press stories that arise, we need to recognize and distinguish, I think, between a couple different kinds of reactions we might have. So let me talk about the NSA disclosure, specifically involving Section 215 and the fact that the government is getting access to the entire call records database. In my view, that is not a constitutional question because the call records are not content, so they are metadata akin to the kind of information that the government could get in the physical context through public surveillance. But it's very troubling that the government has this power, and it's troubling for a couple of different ways. The first way it's troubling is that if you looked at the surveillance statutes which were trying to regulate this kind of surveillance, this kind of acquisition of information, you wouldn't be able to predict that this is what the government was doing. And I think it's very troubling when the courts are interpreting statutes in ways that authorize programs that you couldn't on their face be able to predict was occurring. Because to the extent that the feedback mechanism is supposed to work in legislation, it's that the public can weigh in on what rules they want, and then hopefully the legislature will adopt rules recognizing those preferences. And in the context of Section 215 and the surveillance laws, you couldn't look at the laws, I think, and say, well, that allows the government to get the entire call records database. When it became known that that was happening, that was a surprise, at least to me and to most other people I know that were following this issue. And if there are sort of secret interpretations of the law that say the law that looks one way really operates a different way, that's very troubling. And it's not really a problem with the Fourth Amendment, it's a problem with how the FISA court is working, and it's a problem with the feedback mechanism for knowing what the courts are doing. And in terms of the role of the legislature in protecting privacy, I'm actually relatively optimistic that the legislature has a significant role and can do a good job in regulating many kinds of high-tech surveillance. I mean, when you look at it today, the news reports in the last few months are not great for this argument, but a lot of what you're seeing now, though, is surprising interpretations of the law, and what we're sort of encountering the problem that once the court has secretly permitted a program that I think could not have been enacted if it were publicly disclosed that that's what the government was doing, it's very difficult to kind of unwind and go back. Because, of course, the president in the national security area has the veto power over changes in legislation. So I think that counsels towards judicial interpretations of the surveillance laws in ways that are strict against the government, kind of a rule of lenity type idea, construing the laws in favor of civil liberties in the statutory area to avoid this problem of secret interpretations that then are difficult to undo in light of the fact that the person in charge of the government's surveillance practices, ultimately the president, also has veto power over legislation that Congress passes. So I think there are difficulties with statutory regulation. None of these solutions are a panacea, but I think ultimately there's a role for the legislature, there's a role for the courts, and the role for the courts should be to try to identify the timeless principles of the Fourth Amendment and maintain that traditional historical level of privacy protection, and that the role of the legislature is to fill in the gaps. And do so in response to majoritarian preferences. Okay, thank you. Miguel?
Well, thank you for having me too. I'm very lucky to go third because people who know a lot more about some of these things than I do have already covered a lot of the territory, and I won't be forced to sort of hold you here sort of against your will. You know, the subject of this panel is the Fourth Amendment and new technologies. But I think it's worthwhile to keep in mind that we have a larger issue with new technologies and the Constitution generally. And things that come up in the context of the Fourth Amendment also come up in the First Amendment. We had cases in the Supreme Court having to do with virtual pornography when you are looking at a child that is not quite a child or a naked body that actually was drawn by Disney. Or you have issues with violent video games. And so you have these issues in any number of other contexts that are not limited to the Fourth Amendment, and you have them, as Orin pointed out, in a world in which the technology is so fast changing that it is very difficult for courts responsibly to purport to prescribe an overriding theory as to how all of this will work out in the future. We have the additional burden in the Fourth Amendment, and I think it's a very difficult problem for the amendment, that the bulk of the law in it, on it, has been made in what Justice Frankfurter said, controversies involving not very nice people. The law of the Fourth Amendment is by and large made in criminal cases, tends to be tied to the exclusionary rule. You don't tend to think about the abstract right that you have to be secure in your houses, papers, persons, etc. as an innocent citizen. When these things get to litigation in the overwhelming number of the cases, you're dealing with somebody that most judges would like to see go to jail for some reason. And I think that has a very negative skewing, a skewing effect on the definition of the rights at issue. I said to Orin earlier today that this basically means that the Fourth Amendment law sort of looks like the First Amendment would look if all of the case law had been made by Larry Flint. And so, so you have that issue. you had the constitutional text, and the current view for the better part of the 20th century, from the Brandeis dissent in Olmsted and the right to be alone, was that this notion of the constitutional text and the common law and private property and all of those old-fashioned things were really things of the past and not really a way to deal with technology. And one of the things that I would like to explore with you is whether that was a little bit unfair to the framers of the Constitution. We have seen with cats, when we finally enter the age of modernity, that we came up with a test that seems wonderfully enlightened. It's sort of empty, circular, and vacuous, but made us all feel very good about ourselves. And there is a built-in circularity and a built-in obsolescence in the CAS test if you really take seriously, as Orin said, this notion that what is a privacy type that society is prepared to recognize as reasonable. I am getting old enough, as is, I guess, Judge Kosinski, who wrote an article on this, to see that a lot of young people have no shame whatsoever about exposing the most private thoughts and feelings to everybody around them. You cannot get on the Acela train without some very poorly brought up people making you party to their entire conversations, which may or may not involve their prostate operations. And so you are fast using all of these technologies to expose yourself, and the younger you are, the more the exposure. And shaping the societal conventions as to what we all expect from each other in a way that raises a fundamental problem about the Fourth Amendment, because as Susan pointed out, this is supposed to be an individual right, but the CATS formula has basically yielded it to the public so that the rest of you, or the rest of everybody else outside this room, simply by dint of being careless and poorly educated, can take away my privacy. And that doesn't seem to make any sense. And so you can think about the progression of the doctrine from CATS, where the court was feeling its way as to how this was going to work. And, the starts are always reasonable enough, right? You have a conversation with your best buddy, you pour your heart out to him, you confess your crimes, and he turns on you. And you say, well, misplaced confidence, he's an informant as a third party. I think people still would say, well, that's sort of reasonable, that's your own damn fault for picking your friends poorly. But then you turn all of your private information to your bank so that you can live in this world, or you dial, the phone, and the court treats those cases as if they were your poor choice of friends. They say, well, you exposed the dialing of the number to the phone company, that was, the Smith case, and therefore you gave it to a third party. You have no privacy interest in it. And then, there's the car question. You drive around in the public streets. What do you expect? People will see you. We move from there to the plane question. You grow into pot in the backyard. There is a fixed-wing aircraft. This is California versus Ciarolo and Dow Chemical. And you look down, and you go, well, common law, that's part of my house. You're invading my house. And the court says, no. We have planes today. And anybody going from here to Atlanta could have looked down 30,000 feet below, and so that you're growing pot. So, of course, you have no reasonable expectation of privacy because the public could see that. Next one is the helicopter, where the cops come over your backyard and hover. And the court still says that that's okay because helicopters are in wide use. You could have your own helicopter. And so this is an ongoing train where the court is basically turning this from an individual right into a purely majoritarian right, which tends to be being diluted with each iteration. And I think, the turning point of this, maybe Orin will say it was even earlier, I would say it's Kilo. Kilo is the case where the cops show up, you're growing the marijuana, it's sort of pretty hot in your house, and they have the thermal imaging equipment that the court very narrowly says, oh, no, that's not okay. You're learning what's going on in the house with the use of technology that is not widely available. why should this make a difference? It's sort of somewhat unclear, but that's Kilo. And then you get to the latest raft of cases, Jones with the GPS case, and then this term we get to the most widely available technology, a dog. And so you go to the stoop with a highly trained dog, and the court says, no, that's not okay. That's an invasion of your house. And the change from Kilo until now, I think, has been less of a choice between the old property view and the new privacy view. It has been the reestablishment of the property view, or the effects view, or the houses view, the textual view of the Constitution, as a backstop, as an additional test, out of a recognition that the privacy view left sort of unhindered was not really working very well. And it turns out that in the latest raft of cases, at least with one exception, you do have results that seem to accord more with the common sense of what people would think is their privacy. But I think the court, in doing that and in refusing to tackle how you were going to deal with this, if at all, with the CATS test, is doing something that, to my mind, is actually quite appropriate, and it is hitting the pause button. Nobody knows how these things are going to turn out. We don't know whether the CATS test really has a long-term viability as a test that can appropriately deal with all these new technologies. But we do know that we can have a backstop for really egregious types of invasions that can tide us over until we figure that out. And I think that that's something to be said for the old dead people who gave us the Constitution in 1789. Now, the second aspect of the Fourth Amendment that I think is unfortunately drawn from the common law is this question of having to link the warrant clause to the reasonableness clause, because the urge to provide procedural protections to the accused forced the court in the 50s and 60s to say that the amendment is not merely about reasonableness, but is about reasonableness being defined as a warrant. You link those two things. The definition of reasonableness usually is a warrant. And that, again, is something that ties the protection of searches and seizures entirely to the criminal process and doesn't leave much of other space. And that, of course, doesn't hold. And so the court comes up with a separate line of doctrine to try to deal with things that seem reasonable in every day. You have TLO, the Jersey case, as to whether a principal can look in the high schooler's locker. And you have the drug testing of the train operator after a crash. And the court, in each of those things, they say, well, there are some special needs that have nothing to do with law enforcement. And we are fine doing that because this has nothing to do with the evil of the amendment, which is going to do searches for criminal purposes. Ultimately, it seems to me that that cannot hold either. And the best evidence that that cannot hold is a DNA case, where you have what seems to be a perfectly reasonable invasion, which is completely indefensible under the criminal law doctrine, because contrary to what the court says, really has nothing to do with the identification of the suspect. But it seems to the court a new technology that they're prepared to say now is worthwhile. And this seems to be such a minor invasion that why not? We don't know what the consequences of that is going to be. But it does sort of seeming to move the court more into a reasonableness mode rather than a protective mode, or you have to have a warrant. Now, ultimately, if you're going to end up in a reasonable world with new technology, I think I'd rather they wait than to give me the new rules, because I think there will be circumstances where the cases that will come to them will be compelling cases that will come to them in the criminal context. And as somebody who will often quote Justice Black, who likes his privacy as much as the next man. I just saved that one for you.
Or woman, you might say.
Well, you recall which case it was.
I don't recall.
It was Griswold.
Oh, was it? Okay.
Um,
There you go. Thank you. Thank you.
Anyway, I'd rather have this be worked out in some sort of process that does not involve the laws that will govern my personal privacy being made in a terrorism case or in a case where somebody has kidnapped and killed a child. And so for the moment, it seems to me that rather than to rush to modernity and to urge the courts to look at these things and come with new and elaborate theories as to how this is going to work out in the future, it is better to take your time, deal with as few of these cases as you can, fully recognizing that in each of these cases there will be a hydraulic pressure to uphold the prosecution, because there will always be a very good case that can be made for people who are not very nice going to jail.
Thank you very much. I would like to ask you a few questions and then later have some questions from the audience. But before that, if you don't mind, I'd like to give Susan and Orin an opportunity to comment on anything Miguel said, or Susan, you on anything that Orin said, because you went first. So please feel free.
Well, you said we could ask questions. I'd love to ask Orin a question. If you probably already know this, but Orin writes like the smartest things on the Fourth Amendment, really trying to make sense of this mess that the Supreme Court has made. And sometimes he actually almost persuades you that there are patterns in there. So I read your piece on the third-party consent doctrine because I was very interested. There are so many critiques of the third-party doctrine that I was interested to know how you bravely defend it. So based on what you were saying, it seems to me what I hear you saying is that one thing that is very useful about the third-party doctrine is that it redresses what you see as a growing imbalance between what government investigators could have seen in public that's now gone kind of indoors and hidden in a private space, and therefore it kind of equalizes what they can do. Now, my first question is, it seems this may just be a question of the glass half full or half empty, but it seems to me that what's been happening is that a lot of what people used to be able to do in private, what was in Benjamin Franklin's desk, is now being forced into public. And so you could look at it the entirely other way, that we're giving the government access to all sorts of things that were formerly private and could only have been obtained with a warrant, which is sort of where Justice Scalia comes from in Kelo and other cases. If you couldn't have gotten it under common law without a warrant, you shouldn't be able to get it. So that's my first question. What do you is this just glass half full or half empty? And the second thing I was wondering, which you talked about more in the article than you did today, was the idea that as Miguel was saying, that the third-party doctrine is based on a kind of consent idea. Partially assumption of risk, but it's partially consent. You share the information. You've agreed to have things done with it. Now, it seems to me that that has become, in the modern world, harder and harder to say. I mean, it's just not voluntary. Even in Smith, Justice Marshall and Brennan said, you don't have a lot of choice whether you're going to share the telephone numbers with the telephone company. So Sherry Kolb says, well, if we're going to think this is about consent, maybe the third-party doctrine should really be limited to where there really is consent. And we should really look at what the parties understood to be proper uses of that material. So what do you think?
Happy to respond. So I think the question of whether revealing information to the public is voluntary is one that needs to be answered by starting with the reference point of physical space surveillance. So imagine no network technologies at all. When you go outside, are you consenting to be watched? Do you have to go outside to live life? I think we would say, you have no choice but to go outside to live a regular life, especially in a world, where you couldn't just click on Amazon and have everything be sent to you. You really would have to go out to the store and go out into the world. It's a shocking idea to many today. But in that environment, you were subjecting yourself to surveillance. The government, if they wanted to, could watch when you were leaving, where you were going. There was nothing you could do about it. And so I think the key idea is there's no right to be free from all government surveillance or right to have everything in daily life be subject to a warrant requirement. Either in a non-network technology space or in a technology space. And so I think that the starting point should be in the pre-network world, pre-third-party doctrine, you, in living a regular life, would expose a lot of your life to government surveillance if they wanted to watch. The government could watch and learn a lot about you. They just couldn't go into your home. And so if we start with that as the starting point, then I think the argument about sort of not being it's voluntary that the government is watching you in the technology space ends up sort of being an argument you could also make about the non-technology space. And then I would also add in terms of sort of things in daily life that are now being pushed out into the network because of how technology is working. I mean, I think the contents of your materials would still be protected, whether it is locally stored or remotely stored. So if you have contents of your hard drive, that receives full protection, and if you decide to use Dropbox instead and store things on a server somewhere, you would get full warrant protection in the contents of your material stored on Dropbox. So my approach would be to say that you still have the protection in that which you used to have protection, and it's just you can't sort of effectively gain protection or gain constitutional protection by shifting from the physical to the network space.
Can I ask one follow-up question on that?
Certainly.
How do you deal with the question, not of the content of what you did or what you have stored, but would you say that the identity of the websites you have visited is roughly analogous to the numbers that you have dialed? And if you can obtain that from Google or from your Comcast server, does it trouble you at all that we have gone from a world in which you can get what's basically a pen registered to a world in which every site you have visited not only is available, but that the identity of the site allows you to infer some of the content?
Yeah, so I think it's kind of it's a great question, and another way of putting it is, you know, would we want a rule that what you do in public is not subject to Fourth Amendment oversight if you spent a lot of the day visiting doctors' offices and places where you might be involved in something that's private that you don't want people to know about? And so my answer would be that I think IP addresses, or the addresses that are hosting websites, are still destination metadata information, so it should not be subject to Fourth Amendment protection. It gets to be a little bit harder once you're talking about maybe a specific story on a website, for example, or search terms in a URL line, I think, count as contents, and there's some case law suggesting that. So there are definitely examples of this that get really tricky. Much in the same way, I think that there's really hard cases as between the exact line between for example, open fields and curtilage in Fourth Amendment law. That's sort of the physical inside versus outside line, which is a four-factor test that nobody quite understands. So there are tough line drawing exercises in the physical context as well. What I think it does point to, and this goes back to the need for strong legislative protections. And so I think in particular, the current statutory privacy laws we have right now are from 1986, the Electronic Communications Privacy Act, which was way ahead of its time. It was regulating internet communications before most people had heard of the internet, and at a time when internet was all caps, so you have to sort of shout it whenever you talk about it. It didn't deal with a lot of the privacy threats that we have today, and I think in particular some of the most private information that we have stored remotely today is that which Google is maintaining about us as the recipient of search engine requests. So people are making 50, 100 search engine requests a day on everything. It pops into your mind and you enter in a search to learn more about it. And that means Google has a tremendous amount of information about individuals. And up to now, Google and other search engines have really fought whenever government investigators want to know about that information. They fight it because they realize that it's incredibly private information. And so we haven't seen cases in which prosecutors, for example, try to get the search queries that a person made from Google admitted in a criminal case. But I think it's really important to have privacy laws clearly protect that information and do so strongly, because it does mean that the network environment just leads to certain information being out there that, even if it's not constitutionally protected, surely deserves strong protection.
Could I ask Miguel a follow-up? So, Orin, you've expressed optimism that the legislature is going to do a pretty good job on that. Miguel, you were saying, let's wait, let's let it settle down, let's not have the courts do this right away in a case involving somebody scary. Are you optimistic that Congress can take care of this well?
Here's my problem. I think we need to shift the discussion to what we want as citizens rather than what the rules of the criminal process are. And if we shift the discussion to that context, I'm somewhat optimistic, but also significantly pessimistic. What happens in the democratic process is a direct function of the ability and the willingness of people to monitor what's going on. And it is often the case in many of these things, as we were talking about earlier, where we start with something that seems like a perfectly safe idea. This will be allowed only in X circumstance. And then that is the signal, maybe the hue and cry, for everybody else who has a pet project who he thinks is extremely important to take advantage of this new resource. So you start with the proposition that in certain cases involving what appears to be an imminent danger to national security and the lives of 20 million people, you are able to get X amount of information, and by the time when people stop paying attention, you have somebody who has his pet crime, which involves the transportation of cockatoo eggs from Australia and the Endangered Something Act, having the full access to the same information, because there is a built-in amount of demagoguery in the system that allows somebody with this cause to come in and grandstand by saying, "Are you saying that this is not important enough?" And so, yes, I'm somewhat optimistic, but I think that turns on the assumption that people, as Franklin said, have a democracy and want to keep it.
Okay, let me follow up on a couple of points that different people have made, particularly this last one here. Katz and the Supreme Court's 1960 forward case law focused on the Fourth Amendment as a protection for privacy, rather than as a regulation of the government, let's say. Is a way of dealing with the problem today to shift the focus from privacy to reasonableness and to decide whether what the Fourth Amendment covers is what we think it is reasonable to allow the government to do in that regard. And how do we go about doing that? Is it better to try to let the courts do that, or are we putting the courts in the position of having to draw arbitrary lines that only legislatures can do? If we leave it to the legislatures, are we running into the problem that Miguel talked about, which is every legislator has his or her own idea of what is reasonable, and so you get a list that starts out with 6 uses for this type of surveillance, and then it winds up becoming 66 someplace down the road. So if we were to shift it from privacy to reasonableness, do you think that's good or bad? And if it's good, who's better at doing it, if anyone?
Okay, I'll start. Yes, I think that would be a good shift. I think part of the problem with the Katz test is that it is focused on what people can expect as opposed to what limits we want on the government. And I've always thought that that was a flaw with the Katz test, especially if you believe that the Katz test truly has a subjective element, which is a matter of some doubt. Why should it matter whether Danny Lee Kilo, however you said his name, expected privacy or what he was doing? I think the rules have to be things where we're talking to agents about what the limits are and what they can do. Now, I think that we may have more or less an agreement in terms of who's better, that we don't want to just ask the question in those black or white terms, that I think that what we're saying is the court probably has to go first and say something basic about the Fourth Amendment, and then the legislature can build on that. We don't expect the courts to be able to deal with all the detail. Orin was saying that, and I think Miguel was also. But I think what the court has to do is clear the deck. What I've been seeing going on, and I once wrote an article about this, there's like this dialogue between Congress and the courts where the court keeps lowering the Fourth Amendment bar, and Congress is so accustomed to the Constitution raising the bar on them that it's like they keep having a battle to see who can go lower. And I think that our legislation at this point is not just that it's not counter-majoritarian, I think it's sub-majoritarian. I think if you truly ask most people what they thought the government should and shouldn't be able to do, neither the courts nor Congress are putting the bar where I think the average member of society would put it. And I think we need the courts to, first of all, tell us that there's something important here, that there are values here that require us to raise the bar. But I do think, Paul, that you're right, that the courts cannot possibly fill in all the details. So I think at that point you do need legislatures to be more specific.
I have one question for you, actually. I was going to follow up because, I was dismissive of the Katz test for turning this inquiry into privacy as to what people expect and taking it from an individual right to a plural right. But there is a fundamental textual problem in that the Fourth Amendment does deal with unreasonableness. And you said in your remarks that you wanted courts to have some core principles. And the question is, by what interpretive method do you identify those? And if you don't really look at what people are prepared to accept, what else is there that gives content to this that is something other than what the judges feel like it? And I will compare this to the Eighth Amendment. You could start it out by saying cruel and unusual punishments were certain things that had a certain level of abuse and indignity early on. We turned it into a nose-counting exercise, and in this day and age, Justice Kennedy is capable of death penalty accounting that would shame Enron accountants. And so how do you come up with a principle that allows courts not to become the abusive rather than the protective parties?
Well,
Susan and then Orin, because I think Orin wanted to address something like that too.
Of course.
Yeah, go ahead.
It seems to me that where I would go back, Miguel, is to Olmsted. The majority in Olmsted wanted to stick to the words of the Fourth Amendment and really be very textual and very, look at history through a very narrow focus. If we had asked James Madison the question, did you mean the Fourth Amendment to prevent telephone wiretapping? If he would have said, that means it doesn't, cover telephone wiretapping. And Justice Brandeis's view in Olmsted, it seems to me, is the jobs that the court really has to be doing, that there is traditional value here, and that we don't want to be asking these specific historical questions about our traditions. As Orin was saying, every generation has a new technology that we have to account for. Justice Scalia's questions in Kelo and cases like that are one version of this. If you couldn't have found this out back in the old days without having the search warrant to enter somebody's physical space, if it was Benjamin Franklin's desk, then we should be trying to protect that private enclave here. Now, I don't think that this is easy for a minute. I don't have a prescription. I've never written an article saying here's what the court should do about the CATS test. I think that the first thing that you have to do is to focus on the values and to focus on the problems that we're having with the existing doctrine and at least clear them out of the way. And I think we need the courts. I empathize that this is a very difficult thing. One more thing that I want to say, though, is that we were talking before about the Fourth Amendment being very majoritarian rather than being really interpreted as an individual right. And it seems to me that the court has always exercised a kind of Fourth Amendment exceptionalism. They just see the Fourth Amendment as something that's so different from the First Amendment or the Second Amendment. And I think some of that is because the word reasonable is in there. And they do seesaw balancing, one-to-one, would you rather have your privacy or your safety, in a number of contexts by just looking at the word reasonable in a way they would never do that in the First Amendment or the Second Amendment. They won't look at less restrictive alternatives. They never ask that question in the Fourth Amendment context. And so there are a number of things about Fourth Amendment interpretation. You want to compare this to the Eighth Amendment, which I think is also an interesting comparison. But if you look at how the court structures its First Amendment inquiries, the court does identify values there. And we wouldn't all agree always about which values they identify. But I think they just see their role in the First Amendment and Second Amendment and Eighth Amendment interpretation as much different and much more, much stronger than in the Fourth Amendment context.
Orin?
Two thoughts. One on the question of the relative role of the courts and the legislature. I think the legislature needs to take the initial role itself in the courts. I agree with Miguel's take that the courts should be deferential at first as the technology settles, in part because otherwise you end up with courts trying to enact some sort of a rule in light of a technology that's changing very quickly. And an example of this is of the two pending cert petitions involving searching a cell phone incident to arrest. One of them is a smartphone, and the other is a phone from like 2004 that was, just sort of could keep, 3 pictures and 5 text messages and 5 phone numbers, and that's it. And you end up with a very different sense of what searching a cell phone means if you pick one case versus the other. So I think it's important to wait for the technology to settle a little bit before courts start trying to regulate it. I tend to doubt that some sort of judicial statement as to the overall goals really influences or should influence even what the legislature does. I mean, at first I don't think courts can really tell anyone anything they don't already know. It's not like by becoming a judge or a justice suddenly they become deeply wise and can see things that everybody else can't. And then also I'm always
goes the other way.
Yeah, that's probably right. And I'm always skeptical about the idea of a conversation between courts and the legislature because it always seems like a conversation akin to a parent and child. It's like, Mom, can I do this? No. Well, that's a conversation, but it's an uneven conversation, and I tend to think that's also what happens when there's a conversation between courts and the legislature. In terms of whether the judicial doctrine should follow privacy or should it follow reasonableness, I always wondered, do the labels even matter? There's a lot of formal doctrine here, and a good example is the shift from before Katz. There actually was no sort of trespass era. That kind of became a myth that the Katz court suggested. But before Katz, there was no real doctrinal test for what is a search. They would just say, this is a search or this isn't a search. And then Katz comes along, and Justice Harlan tries to formulate the expectation of privacy framework to just try to make some sort of sense as a matter of formal doctrine as to what the court is doing. And then we get the sort of trespass test, although in Jones it's not entirely clear if there really was a trespass. And then in the Hardinus case last year, the court talks about physical intrusion instead of trespass. There's all these labels bouncing around, and I kind of wonder if they really make that much of a difference. I think the really important question is, what's the government going to be allowed to do and what are they not going to be allowed to do? And I think that a lot of the proposals to reformulate Katz or reformulate any of the aspects of the doctrine end up just sort of rearranging the doctrinal boxes, and then you end up still having to ask the same question in each case of, can the government do this? So I tend to think, we can stick with the formal doctrine we have. The really important question is, what principles do we use to apply that doctrine?
Gang, I think there may be some questions from the audience, so if I could now, if you have a question, please raise your hand. Let me just ask, first that it be a question, second that it be brief, and third, of course, as always, be polite. Is someone down here?
Hey, Julian Sanchez with Cato. I just want to push Orin a little, as I like to do, on, I guess, the physical analogy approach in general and its application to the distinction between content and metadata in particular. First, it seems as though, the analogy you pick is in general underdetermined by the facts. I mean, it seems like picking the case where I go to talk to you at your private home is going to trigger a very different intuition than the case where I go and visit you in your apartment building or at the private club we're both members of. And it seems like the trick there is deciding which of those analogies to pick, and then to apply that concretely to internet technology, where you don't just have envelope and content, but many layers of metadata at different levels of the OSI stack. There's lots of technologies where, for example, let's think of internet pen registers. Normally the ISP is only seeing the packet level metadata, right? Something going between these two servers. It seems as though the courts have decided that metadata is metadata, and so even though the ISP would never normally itself record or even look at information about what particular individual users are connecting at a chat server or between the user level information about two email servers, which if I happen to run my own email or chat server might never be information a third party has access to, that still pulling that off the backbone is okay. And it seems like the analogy choice there is sort of thorny. How do you decide which analogy is appropriate?
Yeah, it's an outstanding question. I mean, what you're pointing out is that the distinction between content and non-content information can be contingent. It can depend on, there are a lot of questions that you have to answer as to exactly how it should apply, specifically when the monitoring is occurring by a third party that is not acting sort of as a party to that communication or that information that's being acquired. And it's a great point. And my first thought, sort of point well taken. This is a hard distinction to draw. But I wonder, what are the other options here? So there's sort of three sort of rough approaches you could take to the question of how the Fourth Amendment should apply in the network environment. You could say that it protects nothing. Fourth Amendment just does not apply. Everything sent out into the network is revealed to some third party. And then the answer is, sorry, whenever you use computers, you have no expectation of privacy. There's sort of no Fourth Amendment protection. I think that would be bad. Or you could say everything is protected, sort of every piece of information. Whenever you decide to use a computer network, it's like everything is inside your home. And that would mean that if you want to engage in some sort of wrongdoing, all you have to do is do it over a network, because the government won't be able to see you because they won't be able to get a warrant, because they won't have probable cause, and they won't be able to get to probable cause because everything will need to start with some surveillance, and all surveillance will require a warrant in the first place. So I think that would be bad as well. And if those two options are off the table, then I think you have to look at the data and start saying, okay, some of this data should be protected, some of this data should not be protected. What principles should we apply to distinguish the more and less invasive information? And so it's the answer to that question that I think that my approach is trying to answer. And I'll concede that once you've announced sort of, okay, Fourth Amendment protects contents but not non-content information, how that applies with respect to surveillance at different points is not answered necessarily. There are going to be some difficult questions. So fair point.
Let me ask one question of the panel that I've been wondering about. Can this problem be regulated through the uses to which the government can put the information? In other words, a form of an exclusionary rule regulation.
No.
They can obtain the information for some purposes and use it for some purposes, but not others. And if it doesn't work, why not?
Well, I would start with no, because that doesn't deal with the collection, really. And it seems to me that using the exclusionary rule is not that great a deterrent here. First of all, as Miguel points out, the exclusionary rule only arises in cases where you have a criminal, as opposed to the many, many innocent people who will be involved. Second of all, the government has complete control over the use of the evidence. They don't have to bring the prosecution. They don't have to use that evidence. So it seems to me that that's not going to be all that much of a deterrent to say you can't use it. But to me, the chief thing that I think that misses is to miss the innocent people and to miss the problems in collection itself.
Yeah, and I think use restrictions can be are an important part of the overall privacy picture, but it's tough to rely on them too heavily because, of course, it just creates the pressure to expand exceptions and keep expanding. As we've seen in the context of the Wiretap Act, there's a requirement that there be a predicate offense before the government taps a telephone, and that the list of predicate offenses just gets longer and longer and longer. And when Congress wants to do something, fight crime, one of the proposals is always to add yet another crime to the list of predicate offenses. So the list just gets longer. It's not that significant a barrier. It's a part of the picture, but it's not going to be something you can rely too much on.
Can I ask a question of both of you? To what extent is the problem primarily the third-party doctrine, and are there options in the third-party doctrine other than all or nothing? In other words, it's okay for you to talk to your best friend who turns out to be an informant. That doesn't seem to be even arguably covered by the Fourth Amendment. But if you give your briefcase to your friend, the Fourth Amendment would take that into a question of the third-party doctrine coupled with standing, the Rackus doctrine. And isn't that what the problem is? Because my briefcase is still my effect. I gave it to you on the condition that you safeguard my effect. I don't particularly see why the government should take it from you. And is that a problem of standing doctrine in the third-party doctrine? And is there anything that can be done with that to mimic the protections that the Fourth Amendment will give to your effects without going all the way to you can't use informants?
Yeah, so the Fourth Amendment cases, just in case you're wondering, on briefcases and handing over a briefcase to someone, say that when you hand over your briefcase to someone with the understanding that they won't look inside, you maintain your Fourth Amendment protection. So if you walk into a store and you hand your bag to the clerk and they store it there, the government can't go over and take a look at the bag. And the idea is almost like a bailment notion.
That's Stoner.
And it's retained, I think it should be retained in the network setting as well. So this is the question raised by third-party storage more generally. When you have Yahoo, in the Warshak case, you have a remotely stored email that's held by a provider. They're holding it for you, and the Sixth Circuit held correctly, I think, that you have Fourth Amendment protection in the contents of that, of all of that, that which is held on your behalf. So I think that notion of bailment should be maintained across the board, and at least so far.
Susan, you get the last word tonight.
Well, following up on this, I think that there are ways in which the third-party doctrine could be limited, both by courts and by legislatures. And one kind of limitation Orin is pointing to is it gets back to the consent notion that you don't really consent to have somebody rifle through the briefcase or have your ISP read everything you're doing. And there's something in there that both courts and legislatures could do something about. Seems to me another part of the discussion about having a limitation on the third-party doctrine is just about the scope of the intrusion or even particular locations. So as you know, there have been a number of people who have just said the third-party doctrine just really shouldn't apply to the internet. You know, it's just different, it's just too much. In the same way that the Jones case is saying, even though you can follow the car, once you put on the GPS device for 28 days, it's too much information.
Well, listen, thank you all. I appreciate it greatly. I know I have learned a great deal, and I'm sure everyone else has. Thank you for coming, and we're closed.
Thank you.